All right, everyone. Thank you so much for joining us tonight. I'm just going to go ahead and get started with the introduction, and we may have some more people joining us as I go. My name is Farron Stalker. I'm the volunteer coordinator at the AIDS Legal Referral Panel, for any of you who don't know me. We're very excited to have you joining us tonight for this presentation, Transferring Assets at Death. Do you really need probate? With Sandra Price, one of our wonderful panel attorneys. So I want to just begin by thanking the HIV Legal Services Fund of the American Bar Association HIV/AIDS Impact Project. They have given us generous funds that are helping to support our MCLE training series this fall. Before we get started, I'll just give you our brief agenda. I'm going to begin with this quick introduction and an overview of ALRP. I'll then introduce our presenter, and she will provide the substantive training. And we'll save some time for questions at the end, and we'll wrap up by 7 p.m. Pacific time. Quickly for some housekeeping, you should have received the materials in an email from me this afternoon. Please send me a message in the chat or shoot me an email if you have not received them yet so I can make sure you get those. And we'll reserve time at the end of the training for questions. So, and I think our presenter said that she's happy to answer questions throughout as well. So as we're going, if you have any questions that pop up, please put those into the chat or the Q&A. You can also use the raise hand feature in Zoom if you would like to ask your question verbally. And then ALRP is a certified MCLE provider in the state of California. So we are glad to provide 1.5 hours of general CLE credit to California attorneys who are joining us this evening. So I hope you'll take the time to complete our brief evaluation at the end of the training, which should appear in your browser when you exit Zoom and will also be included in the follow-up email tomorrow. Evaluations are required for those of you seeking CLE credit. So once I receive an evaluation back from you, I will email you a certificate of CLE credit for your records. And then we're recording this training and we'll eventually be sharing it as a resource for anyone interested. So I'll be sure to share out the information with you once that training has been published and is ready to view on demand. We also have several other trainings this spring. This is our full flyer for the season, and we're about halfway through now. But the next up on May 25th and 26th, we have a two-part training, Bankruptcy Basics for Low-Income Clients. And then we have been giving a 3-part privacy series, and we'll be wrapping that up with part 3 on May 27th. So if you're interested in joining any of those trainings, they're all free and open to anyone. So you can find more information and the registration link at alrp.org/events. So it's wonderful to see many familiar names joining us here this evening, but some of you are also new to ALRP. So I'm just going to give you a very quick introduction. Those of you who have been attending a number of trainings this season will have heard me make the same spiel a few times, so please feel free to tune me out for the next minute or so. So ALRP was founded in 1983 in response to the AIDS epidemic. And at the time, ALRP was simply for attorneys who were drafting wills and durable powers of attorney for those who were dying of AIDS. And drafting those legal documents was really important to allow individuals to die with dignity and fulfill their wishes about healthcare and disposition of assets. Treatments have evolved, and so too has ALRP in response to that. We're no longer dealing solely with end-of-life planning, and now do a number of different legal work with a number of different legal areas. And since 1983, we've handled over 80,000 legal matters for our clients. Now, we're somewhat unique in our provision of legal services in that we offer services in-house with our staff of 12 attorneys, in addition to operating as a lawyer referral panel. So we maintain a very large and diverse community of volunteer attorneys. And between our staff and our panel of over 700 volunteer attorneys, We help our clients in a variety of legal areas, including immigration, housing, employment, insurance, and government benefits, just to name a few. So our goal in offering these trainings is twofold. First, we hope to increase the capacity of the attorneys on our panel and other legal services organizations, providing services to people living with HIV/AIDS. We also hope to recruit new talent to join our panel and help us meet the growing legal needs of people living with HIV/AIDS in the San Francisco Bay Area. So if you are a local attorney that is not yet on the panel, I hope you will consider joining our ranks. There are a number of benefits to doing this pro bono work with our clients, who are always very grateful for your assistance, and you playing a key role in helping us to provide low-cost legal counseling and representation to our clients. We just ask that panel attorneys accept 2 referrals a year, and we can really tailor the experience to your expertise and your availability. And oftentimes a referral is just a quick 30-minute phone call. So in return for your service, there are a number of benefits for being on our panel. Those include these free MCLE trainings. As I mentioned, we have about 700 volunteers on our panel, so there's a great wealth of expertise amongst them, and we're always happy to connect you with a mentor if you need some mentorship in a certain area of law. We offer malpractice insurance and a number of networking opportunities as well. So if you're interested in joining the panel or learning a little bit more, please don't hesitate to reach out to me. This is my contact information on the slide here, and you received that email from me with the materials. So I'd be more than happy to answer any questions that you might have. So now, without further ado, I'm going to introduce our presenter for this evening, Sandra Price. So Sandra Price of Seidman Bancroft has practiced exclusively in the trust and estate field for more than 30 years and has particular expertise in post-death administration, both in court-supervised probate proceedings and where court supervision has been avoided through use of a revocable trust arrangement or statutory alternative. Ms. Price is a fellow of the American College of Trust and Estate Counsel and is a certified specialist, estate planning, trust, and probate law by the State Bar of California Board of Legal Specialization. She is co-author of Complete Plans for Small and Mid-Sized Estates, an action guide handling post-mortem trust administration, a checklist, both published by the California Continuing Education of the Bar. Ms. Price was also the author of 2 chapters in the award-winning Treaties California Trust Administration 2nd edition. She has been on our panel since 1992 and presented MCLE trainings for ALRP over the years, so we are very grateful to have her here this evening. So everyone could please join me in giving Sandy a warm virtual welcome, and I will hand it over to her.
Hi, everybody. Thank you for coming. And as Farron mentioned, I think if you have questions as I'm going along, I would appreciate it if you put it into the chat or the question and answer. And hopefully I'll see them so we can answer them as they come up. Otherwise, I'm just going to be a talking head here on a topic that is already dry enough. I told a friend of mine who doesn't do probate or estate planning what I was doing tonight, and she just kind of looked at me in disbelief, and she said, "That sounds like a joke. Transferring assets at death, you need a probate? That sounds like Mad Magazine." So, this is very informative, and if you're in the area, it's got great information. But it can get a little dry, particularly if I'm just, I'm going to follow the outline pretty closely. And so the first page of the outline basically it acts like a table of contents almost. It doesn't have the page numbers, just to kind of get you focused on what I'm going to be covering. And I'm going to start with some sort of terminology almost about what is a probate and why does everybody try to avoid it. And I think the first thing I want to say about that is that it's not the worst thing in the world. There are situations where it's absolutely preferable because you wind up having a forum to make sure that things get done properly with the judge looking over your shoulder. But it's basically the rules of the game that society came up with to make sure that a number of things are addressed when someone dies. So there has to be a forum for establishing that there is no valid will, or that determining which is the last valid will. Basically, how are you going to be operate? What are your instructions moving forward? It lets you know who the right beneficiaries are. It's a place to collect all the information about what the assets and liabilities are, to make sure that all of the debts are paid, because the ultimate goal of, after anybody dies, whether you use probate or some other alternative, is to make sure that when the beneficiaries receive the assets of the person who died, that they're free and clear, that beneficiaries don't have to worry about some creditor knocking on their door 6 months, a year, 2 years later, and saying, your dad owed me this money, you need to pay me out of what you inherited from him. Also, it ensures that only authorized people act on behalf of the decedent's estate. And all of that attention in a court-supervised process is what makes probate so people want to avoid it. And particularly in California, the probate procedure is very heavy on court involvement. A lot of other states have much more streamlined procedures, but in California, it's very hands-on by the judge. And particularly in COVID times, the limitations of having a court-supervised process became really apparent. Things are being scheduled 6 months out in some cases. I have a matter where we were petitioning to close the estate, and my client is actually a beneficiary who stands to get a really large check written to her. And the petition was filed, I think, last July, and it was heard in March, and we still haven't gotten the order from the court. So it's going to be almost a year at this rate between actually taking the step by which she would be able to receive her inheritance and having the court issue the order that establishes that. So, as I said, the probate is a good process in that it accomplishes a lot of important goals, and it's bad because it can be very time consuming, and it can be costly. Even the filing fees have gone up tremendously. So just going into court to file anything, adds thousands of dollars to the cost of anything at this point. But as I said, particularly if you're in a dispute situation, or there are family members who really, there's disharmony in the family and nobody trusts anybody else, sometimes having the court monitoring every step can be a blessing in disguise, because you don't wind up having somebody do bad things and and then nobody ever finds out about it. But the court's always looking over the shoulder and will do its best to right it. So some other preliminary things I wanted to get out of the way, and a lot of them are in the footnote, are the difference between heirs and beneficiaries. Heirs are people who take under the rules of intestacy. It's blood relationships for the most part. And beneficiaries are people who are named in a document. You can override the heir default that the law provides. And the difference between an executor and an administrator, hopefully you won't ever have to go and start a probate, but if you do, there's a slight difference between an executor and an administrator. And the other sort of preliminary comment I wanted to make, which people get confused about a lot, is that a power of attorney has no validity once a person dies. So if you have someone who's been helping a sick individual and acting as their agent under the power of attorney, they can't continue to use that as their authority for taking actions after the person dies. And the other point of confusion is that there's a difference between being nominated in a will as an executor. That's just a nomination. That person has no authority to do anything until the court actually appoints them. And that's a fairly lengthy procedure just to get appointed executor. But I have very sophisticated clients who say, oh, I'm the executor. And it's like, well, no, you're not. You really don't have any authority until the court appoints you. You were nominated and you were named as executor, but that doesn't really give you the right to do anything. So having said that probate is something we want to avoid for the most part, I'm gonna explain what my approach is when someone walks in the door and says, my mother died, my father died, my sister died, my white spouse died. First you have to look at all of the assets, and you have to be very careful about how they're titled, because titling really drives a lot of the decision making as far as what procedures are available to you. And then first I identify the non-probate assets, and I'll talk about this more, but things like joint tenancy, those don't have anything to do with the court probate process. They just pass by operation of law to the surviving joint tenant. So if you see things like joint tenancy, those are just off the table. They don't have to be probated. There still are steps you need to take, but even if you had to open up probate proceeding, they wouldn't be part of the probate process. Then I look at what other statutory provisions apply that will also eliminate the need for a probate proceeding. And the rest of this outline here is mostly discussing those. And also I've got a lot of attachments that have the forms so that you can see what they look like. And you can also frequently get rid of a lot of assets that way. And then only what's left would be subject to probate. And I have an example, a hypothetical that's on the last page that just is a good demonstration of how size has nothing to do with it. I mean, this is a situation where there were $5 million of assets, and when I went through and analyzed them, there wasn't any need to open up the probate. There was some shortcut that applied for every single asset. So we'll go through that at the end. Just a word that spouses and registered domestic partners are not treated equally, and same-sex spouses are treated the same as different sex partners. I have some further resources. Those are all good. And now that the introductory stuff is out of the way, does anybody have any questions? I guess not. Okay. I'll launch into the substantive stuff. So there's a class of assets that are not probate assets at all. They pass directly to the beneficiary. And those are things that, like life insurance, heirs, pensions. Those are in the nature of a contract between the life insurance company or the IRA custodian and whoever, and the decedent. And the nature of that contract is, when I die, you pay whoever I've designated. So there really isn't any need for the court to determine anything. It's just all bundled up, and the person who's entitled to it needs to go and approach the life insurance company or the retirement plan custodian and collect the benefits. So I've listed at the bottom of page 3 and page 4, some of the kinds of assets that fall into this, which are generally very easy. You just have to jump through the hoops that the company wants, whatever forms they want you to fill out, and whatever attachments they want you to provide. And just be aware that every business has their own forms and their own procedures. Heaven forbid anybody should have something that you could use what you used for the last one. And that sometimes it comes up with this no beneficiary designated. Either that's because the decedent just never got around to naming a decedent, or perhaps the person you named had predeceased. So there isn't anybody to, there isn't any beneficiary. In that case, you really have to deal with what the contract is, the agreement between the decedent and the IRA custodian or the insurance company. And different plans and agreements have different approaches. Some of them default to the estate, in which case what they mean by that is they'll write the check to the executor. And depending on the size of that retirement or insurance policy, you may have to open up a probate just to be able to collect that asset. But if it's small enough and falls into some of the other small estate procedures that I'll talk about in a minute, you can use one of those to collect those kind of assets. If the estate is the person who is entitled to the asset, to the policy. And some other policies or plans just provide that heirs get it, in which case they'll have their own procedure for how you prove to them that you're the appropriate heir. So, and for those, the priority of heirs is set out in the probate code under the rules of intestacy, which is, I have it written down somewhere in the outline here, but I think it's probate code 6400, and it's basically spouse, children, parents, siblings, and then it just keeps going further out to more remote relatives. So that's pretty straightforward. You just have to contact the whoever's holding it and jump through their hoops. Another kind of asset where you don't have to go to court, it's not part of a probate proceeding, is joint tenancy property. And probably for those of us who've been to law school, we remember that it passes by operation of law to the surviving joint tenant or tenants. And even though it automatically passes as a matter of law, you still have to do something to prove that to the world. So you've got to, get the name on the account changed, or you've got to record a deed, or something needs to be done to actually demonstrate that. I just saw someone asked about a quick deed transfer to my sister that her parents want to do. I'll actually get to that a little bit later. And the other part of the question is a living trust better than a will? And I'll get to that later too. Okay. So joint tenancy, as I said, also requires an extra step. And I've laid out what the steps are. If it's real property, it's an affidavit of death of joint tenant that needs to be recorded. And I have an example of it, attached, so you can see what that looks like. And if it's stocks and bonds, the bank or brokerage will tell you what to do. That is one thing about probate, that you can't get very far without someone telling you what to do. It's hard to do something wrong. It could be delayed, but if it's really wrong, someone's going to put up a barrier and let you know, and you have to, go back to square one. It can be frustrating, but it's not the same as like completely screwing up. So another form of ownership in California, and this is specific to California, is very similar to joint tenancy, but it's for married people, and it's called Community Property with Right of Survivorship. I'm sorry if I'm looking distracted here. Something just popped up on my screen that distracted me. So it used to be that if you had community property, it needed to be probated or to be subject to some short form of court proceeding. But one thing about saying it was joint tenancy was that there was an income tax advantage to doing that. And people were sort of between a rock and a hard place. They either had to do a cumbersome probate proceeding to get the benefit, that income tax benefit from community property ownership, or if they held it in joint tenancy, it would be easy, but they could potentially lose that community property advantage for income tax purposes. So this was legislated into an existence as a way of allowing people to have their cake and eat it too. It allows you to have something be characterized as community property for the income tax advantage, and have the ease of just recording a deed or submitting the right form to the bank or broker to get title perfected. And I said it was recent, but I just saw that it was 2001, so I guess it's not that recent. But for real property on this, you have to do, again, record a real property affidavit, death of spouse, or affidavit surviving spouse succeeding. And I have a sample of that at the end. If there are cars, you should know that the DMV is their own world. They just do what they want. But they do have a nifty little form where you can transfer vehicles without much fuss at all if you don't need a probate otherwise. And for some reason, the form is called Regulation 5. I have no idea why they don't call it Form 5, but it's Regulation 5. And it's at page 17, and it's pretty straightforward. And the other thing that I did not put in the outline, but I should have, is that if you're a AAA member, they can be really helpful in facilitating these transfers. So if the paperwork just seems really annoying, you could take it into AAA and they'll help you handle it. Okay. So another kind of or class of asset that doesn't need to be probated is a beneficial interest under a trust. So that applies in two different separate scenarios. One is if my dad set up a trust with me as the beneficiary when he died. When I die, what happens to that interest in the trust doesn't go through probate because I didn't really ever own it. My dad and the trust that he set up already said what happens to when I die. So the trustee who's been following the instructions all that time about what to do with me as the beneficiary now also has the next set of instructions is what to do when I'm not the beneficiary. So my beneficial interest under a trust when I die doesn't need to be probated. And it also means that assets held in a revocable trust don't need to be probated. The thing about revocable trusts, though, is you can have the nicest trust in the world. If you haven't transferred the assets to it during your lifetime, you're not going to completely avoid going into court. The trick to making revocable trusts work is not only to sign the trust instrument, but to take the extra step to retitle all your assets. And again, it's that same idea that the trustee has the instructions written out in the trust instrument, so he or she doesn't need to have the court supervise what they're doing. Other assets where you don't need to go to court or open a probate are POD and TOD and Totten trust accounts. Those are sometimes referred to as poor man's trusts, because basically instead of a trust instrument, you have an account agreement with the bank that basically, by the way the account is registered, pay on death, the bank knows if someone, if I die, if I set up an account that's POD for my son, all my son has to do when I die is go into the bank, prove that I'm dead, and the bank will release the funds to him. And as long as I'm alive, it's completely my account. My son has no interest. He can't even get any information from the bank about it. It uses my social security number. I can revoke that designation. It's only really operative at death, and which is, for instance, different than joint tenancy. If you set up a joint tenancy, if I have a bank account and I change it to joint tenancy with my son will also just very easily get it when I die, but I have made an irrevocable gift to my son if I've set it up in joint tenancy. This is, I've preserved all my options. I can change it if I want. Again, you just need to go to the bank and jump through whatever hoops they want, or pay on death accounts or bank accounts. TOD accounts are usually with brokerages, transfer on death, and Totten trusts are usually set up for children. But every bank and brokerage will be very happy to tell you what they want. So now this is something new. These are called revocable transfer on death deeds, and they're also sometimes called beneficiary deeds. And basically, it's like a transfer on death account, except it's not an account; it's for real property. What you do is, while you're alive, you deed the property over to basically it says, transfer this on my death to whoever you name. And page 18 is an example of that form. And I take that back. Page 18 is what the surviving beneficiary files in order to perfect title in their name. There isn't actually an example of a transfer on death deed. I apologize for that. But if you Google it, you will find it. So this was very controversial. It came up before the Judicial Council 5 times before it was passed. And I'm enough of a geek that I follow what the Judicial Council does with a lot of legislation. And most of it is pretty dry stuff. I mean, academics write in with these how many angels can dance on the head of a pin kind of academic arguments. And whenever this came up, there were like hundreds of letters, most of them handwritten by people saying, please don't make my children open up a probate when I die. I just want them to have my house. Don't make me go to those mean, nasty lawyers and have to pay them a lot of money. Just do something to make it easy. So there was some sort of orchestrated effort to get this passed, and it finally passed. And I know there were a lot of there was a lot of concern from the real estate lobby. There was a lot of concern from people who were concerned about older people being duped by elder abuse, elder financial abuse situations, because it would be so easy to just have someone sign a deed that transfers this property to someone else, and they would never know, because it doesn't change anything while the person is alive. It's not like the property taxes are paid by anybody different. It's not like the property taxes change. It would just be that when the defrauded elder died, whoever the fraudster was could swoop in and would have right to the real property. So there were a lot of concerns. It took a lot of drafting to address all the concerns, but we finally have it. And I'm not sure how it is working. I generally don't use them in my practice. But there is a lot of information about them. There are a number of details in setting it up properly. So, and I gave you the link. Sacramento County has a particularly informative website with forms. So that's a bunch of ways of a bunch of different classes of assets that don't even get you near probate. They completely avoid probate because they're just that different kind of an animal. And as I said, when someone comes in and we're looking at how we're going to proceed after a death, I look to see, well, are any of the assets titled this way? Because if they are, then just go away, deal with, the bank, the broker, whoever, fill out their forms, and we don't have to worry about opening a probate for those assets. Once you've eliminated those, you're left with a certain number of assets, and there are still a lot of shortcuts you can take, the statutory alternatives. So the biggest one of that is a spousal property petition. And this is really useful for if it's a married person. There's no limit on it. You could die with $20 million, and if you left a will that said, I leave, someone asked whether the transfer on death deed can be done without a trust or will. Yes, absolutely. That was actually the one of the goals, was to provide an alternative to having to do a trust or a will. But be aware that it only, is effective for that piece of property. So, there may be other ways to structure your estate plan so that, the deed, this transfer on death deed deals with the real property. And then there's, just a very small bank account other than the house. So that's for more planning purposes, but yes, you can do this without having a will or trust, and it operates on the house. And then you just need to give some thought when in the planning stage to what else that means. And the other thing I wanted to mention about those is that there was a recent, somewhat horrifying case, and I didn't put it in the materials, but what happened was someone with one of these beneficiary deeds died, and the title vested immediately, even though nothing had been recorded. Title vested immediately in, her son, or whoever she had named. And about a week after that, the house burned down, and the insurance company wouldn't pay because they had insured the mom as the owner, and mom was no longer the owner. The son was the owner, and that was upheld on appeal. So the moral of that story is, if you're dealing with someone who is inheriting property, real property that can burn up, by one of these sort of automatic operation of law kind of methods, make sure that you get the insurance changed as soon as you can. So, okay, so we went through the not probate kind of assets, and now we're going to talk about, even if you have assets that would need to be probated, whether there's alternatives. And I had started talking about the spousal property petition. Very useful. There's no limit on the amount. If I died with $20 million, I should be so lucky, or rather my husband should be so lucky, and I left a will that said I leave everything to you, he could take advantage of this. And it's just a one-shot petition. You just go into court. There's no executor appointed. You don't have to, you do have to identify the assets, but you don't have to value them. And so it's just a one-shot petition. And for real property, for personal tangible property, for personal intangible property, like bank accounts and stocks and bonds, partnerships. It's a judicial council form, and then there's two separate schedules that you attach. There's three things you have to attach to it. You have to attach, if you're claiming that something is community property, and that an asset is community property, and that half of it should be should be confirmed as passing to the surviving spouse, and that the other half should just be retained by the surviving spouse because it's his or hers. You have to provide facts that establish the community property nature of it. And that could just be something as, they were married on such and such a date. They had no assets when they were married. Everything they owned at the time of death was acquired during the marriage. Therefore, it's community property. And this petition just does have to be sent out to children. So, if a child thought that something was not, particularly in a blended family situation, if there was a dispute, the fact that something is being sent out to everyone who has an interest means that people have with an interest and who might contest that it goes to the surviving spouse have an opportunity to step forward and say, wait a minute, that's not community property. So three things you have to attach. One is this statement about why it's community property, if that's what you're claiming, or why it's separate, and why, and then you have to have one attachment. 7A is a list of the assets that you want to be confirmed as passing to the surviving spouse. And the other 7B is the list of assets that you want to be confirmed as being awarded to the surviving spouses just because it's his or hers. He or she just gets to keep it. And I mean, it's for community property, the schedules are going to be exactly the same, except the one 7A is going to say, one half of these assets are confirmed as passing to the surviving spouse from the decedent, and 7B is going to say one half of these assets are confirmed as belonging to the surviving spouse and she gets to keep it. So three attachments, but you file it. It is a notice hearing. You do have to send out notice to family members who, as I said, have the opportunity to object. So for instance, in a blended family situation, or it doesn't have to be a blended family situation, but if there's no will, separate property only passes a third or a half to the surviving spouse, and the other piece goes to other family members. So if the surviving spouse is claiming it's community property and I get all of it, I keep my own and I get the half. Someone else from the family might say, not so fast, that's separate property, and we're entitled to some of it. So, but it does provide a forum, and it's a pretty easy procedure. Although I will warn you, the probate courts at this point are incredibly backed up. It's really frightening. All the Bay Area counties. So one of the questions is, what is the probate code for transferring to the surviving spouse? And do you mean for using this spousal property petition? Okay, so it's probate code section 13650. And actually, I've pretty much tried to keep probate code sections in the outline so that you have them for reference when I'm not on the screen here telling you. So, okay. So the one limitation is, and I'm not sure where this comes from or why this was ever introduced into the code, but you have to have a 40-day waiting period. So it's not like an instantaneous thing, but in my experience, people don't usually get around to dealing with these things for 40 days anyway. So some of the disadvantages are compared to probate is that it doesn't cut off claims. One of the advantages of probate actually is that creditors have 4 months to step forward and make their claim. And if they don't, they've forfeited their right to get paid. That doesn't happen in a spousal property petition. Also, this is only a California procedure, so if there's out-of-state property, you may still need to do an out-of-state probate. There's no statutory attorney fees for this. It's as agreed upon. So, okay. So the next shortcut is collection by affidavit, which is probate code section 13100. And this is also useful for small estates or in large estates where most property passes somewhere else. I've been involved in some very large estates where everything was an irrevocable trust and didn't need to be probated for that purpose. And it's like, oops, we forgot about this one bank account and it has $100,000 in it. Please don't tell me we have to open up a probate for that one asset. And I can say, no, you don't. You have a cushion. And that cushion is currently $166,000, $166,250. If any of you have been doing probate for any length of time, this has been inching up over the years from 100 to 120 to 130 to 150. And the last time they revised, and every one of those changes required a legislative change. And what they finally did this time was they made it 166,250 is 150 indexed for inflation over some period of time. So that's where the 166,250 comes from. And they automatically built in an inflation adjustment so that it doesn't have to be legislated every time moving forward. Again, there's no court involvement. This will not work for real property. This is only for personal property, and it can be personal tangible or personal intangible property. And any beneficiary can use this. And it is sometimes useful for things that you don't necessarily think about. If, Grandpa forgot he had a $10,000 policy where he named me as beneficiary. No, that's not a good example. Where there is no beneficiary, but I'm the heir. So I would be the heir that would be entitled to that $10,000 policy. I can use this affidavit to collect that policy from the insurance company. If I give them an affidavit saying I'm the person with, I'm the rightful person entitled to this, and I declare that under penalty of perjury. And the idea of this collection by affidavit for what they're considering a small estate is that they wanted to uncongest the courts of small matters. And as I mentioned, over the years, the definition of what's a small matter that's too small for the court to bother with has increased. And the way that the opposition to to banks not like releasing funds, or insurance companies not releasing funds without knowing that it's a court-supervised probate, is that they're afraid of liability, that they don't want to, they want to have some assurance that, you know, with a court order, that they're giving this to the right person. And the way this works is that basically the legislation provides that the person who's claiming it is saying under penalty of perjury that they're entitled to it. There's no one with a superior right to it. And if it turns out that they're lying, well, then that the person who made the declaration and the person who really should have gotten the money, they can duke it out. But the bank or the, you know, whoever, the insurance company, is released from liability. They relied in good faith on an affidavit under penalty of perjury, and they had no reason to believe it to be fraudulent. So that removed the liability concern, and that's what makes this work. And there is no judicial counsel form for this, but the statute is very clear about what the affidavit needs to state. And if you just Google it, you'll come up with a form. Not as useful, but sometimes in the right situation, an affidavit for real property of small value works. And this is for real property of $55,425. And particularly in the Bay Area, it's very hard to imagine ever being able to use anything like this. But you know, I have had people with like mineral interests in, you know, far off counties where the mineral interests were considered real property, where it fell into, we were able to collect that real property using this procedure. The court, as in a judge, is not involved. You do have to go to court and file this affidavit form, and it is a judicial counsel form. You have to file it with the court, and then you take it and you record it. So it's not like there's a judge making any kind of a decision and there's no noticed hearing. So it's pretty easy if it applies. Similar, but a little more complicated for real property is a court order determining succession to real property. And this is Probate Code Section 13150. And this is also a judicial counsel form. This does require a hearing. And it does, and you do get an order from the judge. You have to notice it's works for property, the real can't exceed 166,250 again. And again, in the Bay Area, you think, when is that ever going to be able to be used? But I actually had someone who had a condo in, and this was when it was 150, had a condo in a assisted living facility where the market is very depressed. The value is very depressed because there's a limited market that it appeals to. And it was under $150,000, and we were able to use this procedure. It was great. And you for this one, you actually have to have a probate referee value the property. The court wants to see that it's under the 166,250. So, okay, so another shortcut is a small estate set aside to a surviving spouse and children. Again, only limited to a particular class of beneficiaries. And this is fascinating to me. This used to be $20,000 that a surviving spouse or child could collect without going to court. And you do have to go to court, but it's a very simple procedure. And this was 16,000. And then when they changed the law last year, they bumped it all the way up to 89,500. I thought that was fascinating. This is the one that I was getting confused with. A surviving spouse can collect compensation up to $16,000 by going directly to the employer and collecting it. If and it's a there isn't a judicial counsel form, but the probate code section 136001 gives you the exact language you need to use. So one other shortcut for using, for avoiding a full-fledged probate proceeding is something called a for the longest time, they were just known as Hegstead petitions. And basically, this works if you have a revocable trust as your primary estate planning tool. And as I said, revocable trusts are great, but they really only work to avoid a probate if you've transferred the assets into the trust. And for anybody out there who does planning, you know that you can talk until you're blue in the face and it just doesn't happen. Some clients are great, some of them are sort of great, but even the really great ones occasionally will forget about a bank account or they forgot that they're going to inherit $200,000 from their mother, and it came in after it was due after they died. So for situations like that, where you're using a revocable trust as your primary estate planning tool, and you're over that 166,250 that would let you use those kind of statutory judicial counsel form shortcuts, you can petition the court based on case law where you're asking the court to say, look, I know this wasn't titled in the name of the trust, but it was intended to be in the name of the trust. The entire estate plan is predicated on the trust disposing of all the assets. This person had a pour over will. Even if you opened up a probate, all you were going to do is wind up with an order after months and months and months that says, transfer it into the trust. So let's just cut through all of that and please give us an order right now that says this is a trust asset. And it works. If your estate plan has been set up to allow it to work. So if you've got a general assignment, if at the same time you do your revocable trust, you assign an assignment that says, I hereby transfer all of the assets I own, whether or not I get around to changing title. It's a good way to just get those little rogue assets that didn't get into the revocable trust so that all of the assets can be administered together by the trustee and you don't have to deal with opening up probate just for that one. I call them rogue assets. It used to be that it had to be real property and that the trust document had to be in the form of, I declare that I've set aside this asset. And over the years, there's been a few other cases that have enhanced that. So now there's case law for intangible personal property bank accounts and even real property, if you can show that the property existed at the time that you made out that you signed the trust and that you had an estate plan that contemplated that it was all going to be administered in a coordinated way under the terms of the trust. So those are pretty much the ways of avoiding probate. And I thought I would just talk a little bit about so what's so terrible about probate? What if you can't avoid it? And mostly it's just that it's so court supervised. You have to have a petition to admit the will to probate. And that's a hearing, and you have to publish notice of it. And if there is no will, then you need to, do that. And anything can go wrong. Someone can step forward and say, I have a later will, or I think that will was signed under duress, or, so, I mean, that is what probate is designed to do, but there's all sorts of things that can slow up the process. You have to send formal notice to beneficiaries. I mentioned publication. Then the court appoints the personal representative. And when the court appoints the personal representative, they issue probably the worst wording of any document in statutes. They're called letters testamentary or letters of administration, and they're not letters at all. They're a judicial counsel form that is it's the document that says this person is the executor and or the administrator and has all the authority of that office. And that is what every bank, broker, title company, mutual fund, anybody who's dealing with an estate after someone has died wants to see letters, because those are the official document which establishes your authority to speak for the estate. And sometimes when I talk to lay audiences, I give the example of, if you're in the middle of selling your house, when I'm in the middle of selling my house and I die, and my sister steps up to the buyer and says, oh, don't worry about it. I had her power of attorney. I've been signing all her papers for a long time. She's been sick for a long time. I can finish signing the contract. If you as the buyer are going to take that, take that as a way to proceed, probably not. And even if you were trusting and did, the title company wouldn't let you get away with it. The title company is going to need to see the letters testamentary. That's the official proof that that one person has the authority. No matter how many other people say they have the authority or think they have the authority, it's only those court-issued letters that actually bestow the authority. So anyhow, so after the will is admitted or it's determined that there is no will, and the court issues these letters testamentary, that's kind of the walking papers for the executor administrator to proceed to settle the estate. And settling the estate includes marshaling the assets, which means finding out about all the assets and making sure that you get control of them. So changing all the bank accounts to the executor's name. Usually most executors actually close existing accounts and consolidate them into one new estate account. But you've got to inventory the assets as of the date of death. And then they need to be appraised by a probate referee, which is a state appointed person who appraises them. The inventory gets filed, and all of that, what the decedent owned and the value of what the decedent owned is all public. It's out there for the public. And a lot of San Francisco, for instance, has all of that online. Actually, it doesn't have inventories online, but it has virtually everything else. But you could go to the courthouse and when it opens after COVID and see what it owns. And I had one attorney whose wife died, and he had his law practice as a sole proprietorship. And when his wife died, her community half of that law practice had to be inventoried. He was just horrified that all his receivables, all the value of his office furniture, all of that got included on the inventory for all of his friends and competitors. to see. So that's another reason people don't like probate, is that it's a very public process. So you file the inventory, you get the assets appraised. That's a filed document. You have to handle creditor claims. You have to manage the estate assets during administration. You've got to, and then once everything is wrapped up, you've identified all the assets, you've valued them, you've paid all the creditors, you're ready to pass what's left on to the beneficiaries. You have to petition for final distribution. You have to distribute the estate assets. You have to file receipts, because you're actually getting an order from the court that says, give this to this beneficiary, give this to that beneficiary. The court's going to want to see that you actually did that you complied with that order of distribution. So, yeah, so you file the receipts, and then in the end, you get discharged from being a personal representative. So, any questions? Okay, well, I thought we would go to the last page and have some fun with my hypothetical. So, so with the hypothetical, a surviving spouse comes into the office and gives you a list of the assets that that her husband died, and that they were valued at $5 million altogether. And she wants your help. And she's heard terrible things about probate. Does she have to open up a probate? And the will provided that his son gets a mining investment. His daughter gets the remaining balance in a bank account, and his wife gets everything else. And as I said, the approach is, first, I identify the non-probate assets. So if we go through this list, well, community property, so that means that he owns with his wife, but a trust for his benefit that was set up by his father, well, that $500,000 doesn't need to be part of any probate. You just erase that from the calculation. The trustee of that trust needs to be notified that Mr. Smith died, but that trustee will know exactly what to do with that $500,000. And Mr. Smith doesn't have to worry about it at all. And it's not going to be part of any probate. Now going down the list, oh, he has rental property worth $1 million with his sibling that's owned as joint tenancy. Well, that's not going to be subject to probate. His sibling just needs to go record a deed that establishes him as the surviving joint tenant, and that's not going to be part of any probate. Life insurance, we don't know who the beneficiary is, but whoever it is just going to go collect that. The same with an IRA. Whoever is named as the beneficiary is just going to go deal with the IRA custodian and collect that. And then these two assets that the real property, the $10,000 unimproved property, and the bank account that goes to the son and daughter. We'll talk about that in a minute. But anyhow, so the approach of first getting rid of non-probate assets got a number of items off the table. And then let's see if any statutory procedures can help. Well, anything that Mrs. Smith is going to inherit under the will, which is everything other than what the son and the daughter get, she can do a spousal property petition. So that's the $2 million of stocks and bonds. It's their residence for $1 million. And yeah, she just can get those by doing a one-shot spousal property petition. And then for what's left, which is that's $10,000 real property to the son, he can use that small estate affidavit, the very small estate one, the $55,000 one, and the bank account that goes to the daughter, she can use that 13,100 affidavit because it's under 166,500. She just needs to go to the bank and with the affidavit form. And actually, a lot of this is used so commonly with bank accounts that a lot of bank accounts have their own forms, you know, and so you should always ask the bank first, because I've had a few situations where I've custom drafted it and the bank says, oh, we don't use that, we have to use our own form. So out of this $5 million estate, nothing needs to be probated. So just want to show you how that works. So in answer to the question, is a probate proceeding required? The answer is no. So this is very weird not being able to see anybody. Is anybody still awake?
I just saw that we had a participant raise their hand.
Oh.
Oops, now I've raised my hand by mistake. Let's see. Nope, never mind. Hands down.
Oh, okay. So two of the question and answers are, one is that my parents want to do a quick deed transfer to my sister and I. Is this possible? So there's two things that they can be thinking about. It is possible. One is, if they want to do that now and transfer the property to you now, make a gift to you now, then that's one kind of a deed they do, but then they don't own the property. And if they want to put it in joint tenancy, then they could also do that, but they've also still transferred it to you now. And the other thing they could do is one of these revocable transfer on death deeds that I was talking about that are relatively new since 2016. And that's a way of ensuring that the house gets transferred to you when to you and your sister when they die, and they continue to own it until then. So I hope that answered your question. And then the other question was whether a living trust is a living trust better than a will? And that is actually a complicated question. I would say generally yes, because it does give you the possibility of avoiding probate. There isn't any kind of tax planning or any kind of other planning that you can do in a revocable trust that you can't also do in a will. So substantively, they can be structured the same way. The difference is that the living trust is something you set up now, and it sort of proceeds in 3 chapters, or 2 chapters if you're single. But you know, the first chapter is administer the trust this way entirely for my benefit while I'm alive. And then the next chapter is after I die, administer and distribute it this way. And then the provisions that you would put in for at death are the same provisions you would put into a will. The reason it's better, and I'm putting that in quotes, is because it avoids probate. I have had situations where, as I said, where with very contentious families where nobody trusts each other, sometimes it can actually be better to force you into court to make sure that keeping the contentiousness in check, because the judge is always, you're on a track, you have to do things by a certain date, and the judge reviews it, so there's less opportunity for mishaps. So there are situations where a will might be better, but in general, I would say revocable trusts are better. They're a little more complicated as far as drafting, and you do have to take the extra step now while you're alive of transferring the assets to it in order to make it work the way you want. But you know, even for people with very modest assets, it's very easy to administer once you're done, as opposed to having to deal with all the procedural hurdles of going into court all the time for if you use a will and have to open a probate. Okay, so there was one of, so I have 2 questions now. I don't hold on, let me see the beginning of this. Okay, this is someone who has a revocable trust, but primary beneficiaries have died and everything will over to contingent beneficiaries. Do I need to rewrite my trust or create an account with TOD with beneficiaries? So, so do I need to rewrite, once different beneficiaries, and the question is, do I need to rewrite the trust, or can I create an account with a TOD with beneficiaries not named in the trust? You can do that. And then they'll, the assets that are subject to the TOD account will just be collected by the people who are the payees on that account and won't have anything to do with the trust. You might want to look into, you know, other situations. I mean, you need to think about it holistically in a way, because if there are things, if you're going to need the liquidity of that TOD account to pay other debts that are not part of that TOD account, or if, I mean, you can do it. You need to think about it from a few angles to make sure that it makes sense. So the classic, you know, is the man, and I guess you could use either gender, but the man who sets up, you know, a TOD account for his mistress because he doesn't want his wife to know. And in my other office, we had a very wealthy person who did that, and it turned out that his wife ultimately wound up paying the estate tax on that gift. So it turned out to be one of the, you know, talk about rubbing salt in the wound. Not only did she find out about this after he had passed, but she had to pay the tax on the gift he had made outside of the trust. So if you're dealing with a taxable estate, you have to coordinate to make sure that the tax provisions work the way you want them to. So, okay, so in collection by, second question, in collection by affidavit, if you bypass probate and an executor is not appointed, who ensures that the property claimed is free and clear from creditors? Actually, that's a good question. And what happens is that under the statute, the person who is collecting it by affidavit takes on the debts of the decedent up to the value of the assets that they've collected by affidavit. So they're by statute, they're not taking it free and clear from creditors. They're taking it subject to creditors. So, okay, well, we're done a little early, so.
Looks like we have one more question in the chat there. Are there free or low cost services to help with all these different procedures and filings?
Well, I think if the person qualifies for ALRP, then that would be one free or low cost service to help with after someone has died. And actually, the reason I came up with this program is because I had stopped doing actual drafting of wills or taking on probate kind of cases for a while. And I went to mentor status so that panel attorneys who had these kinds of questions would, you know, had me as a resource to ask. And I was fielding a lot of calls where, you know, the attorney would get on the phone and say, I'm filling out the petition for probate and I don't know how to answer this. And what do I do about this? And what do I do about this? And then when I talked to them and got more facts, it was like, why are you opening up a probate? You could do this with one, you know, with one affidavit. And it was coming up often enough that I thought this would be useful to sort of package and present, you know, that there are alternatives. So I do know that ALRP does it. Probably legal aid. I'm not really familiar with other organizations. I'm probably not the right person to ask, but.
Yeah, I also can't think of anything off the top of my head, but you could certainly, and I don't do client services at ALRP, so I'm not the one to ask, but can certainly help you find those resources if you shoot me an email.
Yeah. So, some counties have really helpful probate court resources. You could also check the website. Sacramento County is particularly helpful, and if you check their webs, they really walk you through how to do things. And most of the information is in county specific. I mean, these are statewide laws, so any information you could find using a resource like that would be a good resource.
Thank you so much. If anyone has final questions, feel free to type them in the chat now, but I just want to jump in to say thank you so much for this presentation. It's always great when people are able to ask questions, despite the webinar format. So I'm glad we were able to get to some of those questions. And we're so grateful to have you on our panel and providing this training. So thank you. And for those of you who are attending, thank you for joining us. And just a reminder to submit the evaluation, which will be in your browser and linked in the follow-up email tomorrow. And once I receive that, I'll send you a certificate of MCLE credit. And it seemed a number of you there, I think I looked at my email and my email got stuck in my outbox to some of the recipients, but not all. So if anyone did not receive the materials, please feel free to send me an email and I will get those to you. I apologize for the technical difficulties with that.
Yeah. And if anybody has any questions, feel free to contact me directly. So.
Great, thank you so much. It doesn't seem like we have any other questions, so we will call it a night. Thank you, everyone.
Thanks. Stay safe, everyone.